Imagine owning a house you legally cannot live in. The deed is in your name. You're paying the mortgage every single month. But inside that house sits a mountain of someone else's belongings, and the people who own those belongings have absolutely no urgency to come get them. Meanwhile, you're also paying your current mortgage, you have a buyer ready to purchase your existing home, and the entire deal is just frozen, held hostage by stuff. That is exactly the nightmare one Tennessee family found themselves living through. And what happened next is a masterclass in what can go wrong when generosity, grief, estate law, and family bitterness all collide at the same time. Let's set the scene, because this story starts in one of the most heartwarming ways imaginable before it takes a very sharp turn. A family of 5, living in Knoxville, Tennessee, had spent 6 years building a genuine friendship with their elderly widowed neighbor next door. This wasn't just a wave across the fence kind of relationship. This man had become part of their family. He loved their children. They looked after him. He was, by every meaningful definition, a grandfather figure to those kids, even if there was no blood connecting them. Then came the devastating news. In May of last year, their neighbor was diagnosed with stage 4 cancer. Facing his own mortality, he began thinking about what he wanted to leave behind. He had no children of his own. He had a brother, a niece, and a nephew, extended family. But the people he felt closest to, the people who had shown up for him day after day, were his neighbors. His house was more than double the size of the family's home. They were living in 1,100 square feet with 5 people. And so, this man made a decision that was, in every sense, an act of love. He wanted to give them his house. Now here's where the legal mechanics matter, so pay close attention. Rather than leaving the house through his will, the neighbor did something very specific. He executed what's called a quit-claim deed, transferring the title of the property directly to the husband and wife while he was still alive. This is a critical distinction. A quit-claim deed transfers ownership immediately and outside of the probate process. The moment that deed was signed and recorded, that house was no longer legally part of the neighbor's estate. It belonged to the couple. The neighbor passed away in January of this year. His will directed that all of his estate, his belongings, his assets, should go to his extended family, the brother, the niece, and the nephew. And because the house had already been transferred via quitclaim deed before his death, the estate only included what was inside the house: the furniture, the collections, the accumulated belongings of a lifetime. The property itself was not subject to probate. The family's ownership of the house was solid. But here's where the situation gets complicated in a way nobody fully anticipated. Their neighbor had hoarding tendencies. The house was absolutely packed. We're not talking about a few boxes left in a spare bedroom. The home was, in their own words, in an unlivable state, and every single item inside that house now legally belonged to the beneficiaries of the estate. Let that sink in for a moment. The family owns the house, the extended family owns everything in it, and legally, the new homeowners cannot simply remove the property of the beneficiaries, even from their own home. They have to wait. They have to wait while paying the deceased neighbor's remaining mortgage. They have to wait while paying their own mortgage. They have to wait while a buyer for their current home sits ready and willing to close a deal that cannot move forward because the family cannot move out of their current house until they can move into the new one. Everything is locked in a chain, and the only people who can break that chain are the beneficiaries and an executor who seem completely unmotivated to act. To be fair to the executor, a young, inexperienced individual who was appointed by the state, they may simply be overwhelmed. Estate administration is genuinely complicated work, and when someone without much experience is handed the keys to a hoarding situation, it's easy to understand why the progress might be slow. But easy to understand does not mean acceptable, especially when another family's financial well-being is eroding week by week. The couple reached out and gave the beneficiaries a formal written notice. Generous, reasonable, clearly communicated, you have until June 1st to collect everything you want to keep. That's your window. Come get it. What happened? In the entire period leading up to that deadline, the beneficiaries came out exactly twice. They took the truck. They emptied about half of a shed, and then essentially nothing. Half a shed and a truck out of an entire packed house. The rest remained untouched. And the family's read on the situation is telling. These beneficiaries don't just seem unmotivated, they seem bitter. Bitter that this neighbor, their relative, chose to give his home to his neighbors rather than to them. That emotional undercurrent is important because it suggests the slow pace might not entirely be about logistics. It might, at least in part, be about making things difficult for the people they resent. So the couple did what any reasonable person in this situation should do. They consulted a real estate attorney, and that attorney's advice was direct. When June 1st arrives and the beneficiaries have not cleared out the property, serve them with a detainer warrant. Now, a detainer warrant, sometimes called an unlawful detainer action, is a legal mechanism that forces someone to relinquish possession or access to a property. It's most commonly associated with evictions, but the underlying principle is the same. You are using the court to compel someone to stop occupying or using property that isn't theirs to control. In this case, it would be used to force the beneficiaries to either retrieve their belongings or face court-ordered consequences. The family is scared of this move. They're worried that filing will open a door to appeals, to stall tactics, to prolonged legal battles that make everything worse. And that is a legitimate fear. But let's talk about why the attorney's advice is still probably the right path. Here's the uncomfortable truth about situations like this. Inaction also has a cost. Every week that passes without legal pressure is another mortgage payment, another month of financial strain, another delay for the buyer waiting to close. The family is already losing, slowly, every single day they wait. The question is not whether the legal route is risky. The question is whether the risk of acting is greater than the guaranteed cost of not acting. Filing a detainer warrant creates an official record, establishes a legal timeline, and most importantly, it introduces real consequences for the beneficiary's inaction. Prior to that filing, they have every reason to move slowly. After it, they have a court date. Courts do not look kindly on beneficiaries who ignore reasonable deadlines and hold up property owners. The family gave written notice. They documented everything. That paper trail matters enormously. There are also some additional steps worth considering alongside or even before pursuing a detainer warrant. Consulting with a probate attorney specifically, not just a real estate attorney, could open up additional avenues. The executor has a legal fiduciary duty to act in the interest of the estate. Failure to communicate, failure to manage estate assets, and unreasonable delays can all constitute a breach of that duty. A probate attorney can apply pressure to the executor directly, which may produce faster results than going after the beneficiaries. Additionally, if the financial strain becomes severe enough, there may be grounds to seek emergency relief from the probate court, arguing that the executor's inaction is causing demonstrable harm to a third party. It's not a guaranteed path, but courts can intervene in probate matters when delay is causing active damage. Finally, and this is important, document absolutely everything. Every unanswered message, every visit the beneficiaries made and what they took, every mortgage statement, every communication with the executor. If this ends up in front of a judge, the family that has a meticulous paper trail will have a significant advantage over a bitter, disorganized group who came out twice and left. So what can you take from this story? A few things. First, quitclaim deeds are powerful tools, but they don't exist in a vacuum. When you receive property through a quitclaim deed from someone who still has belongings inside, you need to establish clear, written agreements up front about how and when those contents will be handled. Don't assume goodwill will be enough. Second, when you're dealing with estate beneficiaries who are emotionally charged and potentially acting in bad faith, do not rely on verbal agreements or informal timelines. Everything needs to be written, dated, and documented. Third, inaction is never neutral in a legal situation. Every day you spend hoping things will resolve themselves is a day that costs you money, time, and leverage. And fourth, use the right attorney for the right problem. A real estate attorney is a great starting point, but a probate attorney may be the person who actually unlocks this situation. If something like this has happened to you, If you're dealing with a property dispute, a difficult estate, or a situation where someone else's inaction is costing you time and money, don't wait. Consult a qualified attorney in your jurisdiction as soon as possible. Every situation is different, and the specific laws in your state will shape your options significantly. If you found this breakdown helpful, please consider subscribing. We cover real legal situations like this one every week. The kind of cases that teach you more about your rights than any textbook ever could. Hit that subscribe button and make sure you never miss one.